hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near and give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone, and welcome to the March 14th, 2023 sitting of the Massachusetts Appeals Court. And thank you all for braving the weather to join us. My name is Mary Thomas Sullivan, and together with Justice Sachs and Justice Ditkoff, we will be your panel for today. The usual rules apply today as every other day. Each side gets 15 minutes. There will be no rebuttal. And you can rest assured that we have read with care your briefs and the record, and you are encouraged to get directly to the heart of your argument. 15 minutes goes fast. We have only 3 cases today, so we'll be going straight through with no break. With that, I'll call our first case, which is 22P0659, Joanna DePina versus Kervin Valdez. And I hope I've pronounced everybody's name correctly, and tell me if I haven't. Attorney? Collins Rigorda Eva?
Yes, good morning, Your Honors.
Okay.
My time at 9.
If you'd come to the podium, please.
Oh, absolutely. I'm sorry.
Excuse me, Your Honor. May I just request that I have a safety pin, please?
Ah!
I'm okay with that. Would a bobby pin work? I have one in my hair.
It might, yes.
Okay. I'll give you that.
Apologies.
Or a paper clip?
Yes.
Oh,
I'd be happy.
Okay, the court officer will
Apologies.
get one, and if you know where a safety
no
pin
problem.
is,
I've been there.
I've been there.
Thank you.
How about a couple?
Happens to the best of us. All right. Shall I begin?
You may begin.
Okay. May it please the court, my name is Barbara Collins. I represent plaintiff appellants in this appeal. I will present to you my reasons why defendant's motion to dismiss should be overturned and the case remanded to the Superior Court with a new judge. Some introductory remarks about the case include that plaintiffs are community leaders of service organizations. Joanna DePina is founder of Top-Notch Scholars, which is a youth leadership program in Lawrence.
Counsel, we have read it, but and we know.
Okay,
We know that you said that, but I do want to confirm that the plaintiffs are the individuals and the defendant is the individual.
Yes.
All right.
Yeah.
Thank you.
In their representative capacity.
Well, what does that mean? Do you mean that they're suing personally, or do you mean something else?
Well, they're suing as representatives of the organization. So
Are they
she's
permitted
wearing
to
the
do
hat
that?
I'm sorry?
I'm unaware of a situation in which someone is permitted to do that.
Well, she is.
If I could finish, usually either the corporation sues or it doesn't.
So she is suing, they are suing in their individual capacities because the various defamatory statements were made about them, to answer your question.
Okay, great,
Okay.
thank you.
So should I skip over the facts and just get to the argument?
It's your argument, but
All right.
you started out on something I had a question about.
So plaintiffs and defendants worked on a fundraiser called Everybody Eats, which was a 4-month food drive in the Lawrence area lasting from September through December. And defendants enlisted plaintiff as volunteers, board liaisons, and the companies had nonprofit certifications. The event was sponsored by Justin Bethel of the New England Patriots, and Bethel and Robert Kraft have appeared at other town events doing similar food drives, particularly around the holidays. I've included articles in my exhibits regarding that.
May I interrupt? Is this regarding the suggestion that Justice Howe should have recused herself?
Yes.
Hasn't she retired?
She did retire.
So if we were to agree with you that the complaint was improperly dismissed and we remanded it, it would go to a different judge anyway, right?
I would think so. I have seen judges come back from retirement in different courts, but yes, I hope so.
So is there any reason to argue the issues about recusal.
I could skip over them. Okay, thank you.
Is the conflict over whether or not the turkeys should have been bought at $9+ a pound versus $17 a pound, and whether or not there was an agreement to the higher price?
It started the conflict, and it ended up resulting in an issue over invoicing, which plaintiffs said that they never got proper invoices or any purchase orders. There was a last-minute attempt to reconcile the evening before the event, after the office was closed, and the invoice was actually improper because it was for earlier ordered turkeys, and they had switched to chickens.
So there's the dispute over the price of the turkeys, there's the dispute over whether or not it was properly invoiced, and then additionally?
Yes, and then what resulted was the holidays passed, and our plaintiffs were brought before a BNI group that they were members of, because BNI has an integrity component due to some defamatory posts, allegedly defamatory posts on the internet, which went to the tune of plaintiffs have taken money and used, it to further their own businesses, particularly in the
Where does that
Salvador.
allegation appear in your amended complaint? I see something in the introduction that refers to stolen money, and I saw an allegation in your original complaint, but I don't see an allegation to that effect in the factual allegations of the complaint.
So that's a very good question, Your Honor. That's really the crux of the issue, because that complaint was hurried based on the fact that there was a prior negotiation the evening before.
Well, let's not go outside the record.
Okay. So it is in the complaint, because the complaint reads that paragraphs ahead are all incorporated into each count. And if you look in the incorporated paragraphs, I think it's maybe number 21, I go through in quite a bit of detail and talk about the allegation of money being taken, stolen, essentially stolen.
Are you looking at the amended complaint?
Yes. I didn't bring it up here, but if you look through paragraphs
You have it at your
21
table?
through, pardon me?
You have it at your table?
Let me try to get it. In the introduction and statement of facts section.
That was my question. It's in the introduction, but is it anywhere in the factual allegations? And I suppose, does that matter if it's in the introduction?
I believe it is. I'm having difficulty finding it right now. The paragraph is incorporated above it. So I believe it's stated twice. If you have that, you might find it faster than I do. It is stated.
So the rules say that a complaint, each factual allegation has to be in a numbered paragraph. Now, a judge could excuse that, but why does a judge have to excuse that and consider your non-numbered introductory paragraph in determining whether you state a claim?
I think it's the totality of the circumstances argument. If you read, that's a really good question as well. If you read in reading the appeal in detail, it talks about, at one point, there was consideration of a motion to, for summary judgment, to which opposing counsel replied, there was a query, why isn't this summary judgment? And the answer was it should be. Then there was a discussion of facts, which were brought in by opposing counsel, including the actual text, which was the subject of some controversy. And essentially it was going down the road where there was no agreement as to a material issue of fact. So it wasn't really looking very good for summary judgment, and then we bounced back to a motion to dismiss. That combined with the fact of the recusal, that we had no opportunity to motion for recusal, I think the totality of the circumstances should provide for a cure, and looking at all the other exhibits in the complaint as well.
Why isn't the cure for you to move to amend your complaint again?
Could you repeat that?
Why isn't the cure for you to move to amend your complaint again?
Well, I tried to supplement the complaint, but I was not allowed to do that, and that would have required leave of court. At that point, I felt that the judges, and I hate to keep bringing this up, but it really was part of it. The judge's bias was so much a part of that that I would be denied again.
I thought you didn't know about the judge's bias at that point.
I had a gut feeling something wasn't right. I mean, you do enough cases, you go into court and you sort of see patterns, but did I approve of it? No, that came later.
Let's leave the bias issue aside because it's separate and just go on what the rules
Okay.
of pleading are. You did attempt to supplement, but you did so with an unattested, with no affidavit, so it couldn't be properly converted to a Rule 56 motion, and by submitting a lot of extra complaint material. I didn't really see that as a motion to amend the complaint. Am I mistaken?
Again, Your Honor, you are correct, but I felt that at that point it would not be received well. I know you don't want me to bring in the bias, but the bias really is the crux of the issue, in my opinion.
All right, well, so you moved to reconsider based on the bias, but you didn't appeal the denial of that. So how is that in front of us?
I didn't appeal the what?
The denial of your motion to reconsider based on the bias.
I did put before the Superior Court a motion for reconsideration, and that was presented back to me, at which point there was no admission as to any prior relationship with the judge and the clients. So my client, being a service organization, they didn't have a lot of extra money to spend. We felt that, we weren't getting anywhere, that there was a bias.
But how can we review that when you didn't appeal that denial?
I appealed to this court immediately.
You filed the notice of appeal after the denial of the motion to reconsider?
Pretty much, yes, it was going on almost concurrently.
Where's that in your appendix? Kind of missed it.
Can you point us to where in the appendix the denial, not just of the dismissal, but of the motion to reconsider can be found?
That motion to reconsider was
Not
actually...
the motion, the appeal from the motion.
It was made to this court, Your Honor. The appeal was brought over to this court.
Wait, did
My
you file...
appendix is 400 pages long, so it's going to be difficult
Did you file a
to do
notice of
that.
appeal after the denial of your motion to reconsider?
One more time, I'm sorry.
After your motion to reconsider was denied, did you file a notice of appeal in the Superior Court? Because I
Yes.
don't see one in the appendix. Okay, I don't see one in the docket.
The Superior Court had removed some of my material. If you look at the Superior Court docket, it only allows the first page of my motion for reconsideration. That entire motion was filed with the notice of appeal, so I don't know why the court did not include that, but you can see it was filed because the first page is there.
Are you talking about the notice of appeal dated December, or at least date stamped December 9?
I believe so.
Okay, that is only from the judgment. It is not from the denial of the motion to reconsider.
Well, we went right to appeal. We felt that my clients did not have any money. We felt that there was judicial bias. Even after the second time asking the judge, that she did not come forward and disclose her relationships.
Your motion to reconsider was denied for failure to comply with Rule 9A. Why is that erroneous?
Again, I'm sorry, I have a cold, I don't hear well.
Your motion to reconsider was denied for your failure to comply with Rule 9A. Why was that an error?
Because it would have taken us more time to go back. There was no good faith at that point. I felt that this was the second time the judge had the opportunity to come forward and disclose. The disclosure really should have started the process, not ended the process.
Are you saying you don't have to comply with Rule 9A if the court isn't acting in good faith? Is that the theory here?
You can say so. Again, that would have taken some money and time. The judge really should have come forward at the beginning. I mean, this is a matter of ethics. We should have judges in our Massachusetts Constitution grants us the right for impartiality.
What makes you think Judge Howe has a duty of loyalty to the Patriots organization when she's a judge? You wrote that in your
Because she was,
reply.
another excellent question. Because she was a partner in a law firm in Boston, a very prestigious law firm in Boston, and the Patriots were one of her major clients. She may, even to this day, be receiving money, in the form of benefits, from that organization. Her firm actually did charitable work with the Patriots. They represented the Patriots for a long time. There's lots of information about that in that supplemental motion to recuse, the one that the Superior Court, for some reason, took off the docket and only put on the first page of the database. I don't know why they did that. I can't speak to that. Should I talk about summary judgment? Do I have time, or are there any other questions?
You have time.
2 minutes.
You have 2 minutes.
Okay, so one of the issues it really came down to was conversion to summary judgment. If you look in our appeal, there is a statement made by the opposing counsel regarding the actual text that not only she read into the record, but were presented also by me in the pleadings. And at one point, she starts to say, well, she's making an admission that her client did say that. She didn't get into, substantial truth or anything like that, but she started to make that admission. And Judge Howe actually stops her and says, no, 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 no. So she stops her. She also precludes other information that she had heard, and she basically went back to the motion to dismiss. I think all of these
There was no
examples.
affidavit with your supplemental materials, correct?
Again, I have very bad.
There was no affidavit with your supplemental materials.
I don't remember because that was
Well,
removed from the motion.
My reading of the record, which has been presented to us, and of Judge Howe's decision, is that the documents were completely unverified. And if they're not verified by affidavit, they can't be considered on motion for summary judgment. If she had ruled on summary judgment, you may have lost because there was no affidavit.
Well, if we are getting back to the motion to dismiss, she also discussed threadbare recitals, and I looked at, I actually looked at the requirement for motion to dismiss again. It's plausibility, if you look at Ashcroft and other cases that I've listed in the complaint, it's plausibility with the, references as to the reader, as to the person making the complaint. We had 3 different service organizations. These were service organizations in the community, people who were doing volunteer work, who had nothing really to gain on making these allegations.
Much appreciated, but your red light is flashing.
Okay, thank you, Your Honors.
Thank you.
Appreciate it. Take my little pile.
Good morning, Your Honors. If it may please the court, I'm Attorney Dara Sandow for Curvin Valdez, who is the owner of Town Livery, Inc. I just would like to just get right into the meat of this. The 12B6 motion that I did file before the court was brought on the fact that the allegations that were in my sister counsel's complaint were completely devoid of any defamatory statements. The 12B6 motion that I brought was alleging, based on my sister counsel's facts, that there was an unpaid frozen turkey bill or a poultry bill of some sort relating to the charitable event that my client had engaged in my sister counsel's clients as they were a 501c3. This was a event that was taking place in the community of Lawrence during Thanksgiving, and it relied on donor funds from the community to go towards its intended purpose, which was to pay for the poultry bills around this time. At this time, when the donors from the community had made the payments for the funds for the intended purposes of the turkeys. There was an expectation from my client that the vendor would in fact be paid in this particular scenario, and he was not. Up until this point, even to this day, there still remains an outstanding balance roughly of $3,279.69.
Why does any of this matter in a motion to dismiss?
Sure. So with respect to the defamatory statements that's coming before the court, there is no defamatory statement anywhere in the complaint. There are
The complaint says, defendant made statements that the money had been essentially stolen and that J. Alvarez had misappropriated money in part to further her own business. Why isn't that a defamatory statement?
So that statement is made on a social platform. It hasn't been verified. There hasn't been any statement of facts anywhere in the complaint that even alleges that that was even made. If you read
I just read a statement that it was made.
you read this-
Defendant made statements that the money had been essentially stolen, that J. Alvarez had misappropriated money in part to further her own business.
So those are statements that are made within the complaint, but those are not actual statements provided with any sort of verifiable backup as to where it was made, when it was made, how it was made, who it was made, and that's somebody's opinion as far as that statement is concerned. There isn't a reference point. In order to have a motion to dismiss for summary judgment, there would have had to have been no material facts in dispute that rise to a level for which judgment as a matter of law should enter. We would have disputed that fact had that fact actually arose inside. We didn't even get to an answer side because the pleadings within themselves were devoid of that fact within the factual allegations contained within 1 through 19 of my sister counsel's complaint. The only thing that was discussed in the complaint itself and not referenced by incorporation or even attached thereto is just an unpaid frozen turkey bill in the amount of...
The Mass Rules of Civil Procedure 8F says pleadings should be construed to do substantial justice. Why is that introductory material in the complaint talking about the defendants, the defendants said the money was stolen and that J. Alvarez misappropriated the money to benefit her own business? Why isn't that enough to survive a motion to dismiss?
Sure. So the narrative that is given is an opinion, right? And it has to be substantiated in fact. When we bring pleadings, we look at the four corners of the complaint. And
Well, what part is it is an opinion?
essentially stolen is not concrete. It's not proof. It's an opinion.
It's not proof this is a complaint.
Correct. But the narrative that they're trying to thrust before the court by way of its complaint, it's not supported by the underlying factual statements made in 1 through 19. I would expect after I see something, I'd get a fact that on such and such a date there was a statement, a defamatory statement. There's not even so much as an inkling that there even was a statement made on a social media post, other than what's in the narrative.
It says that the statements were made on social media.
Okay.
That was the statement. The statement was essentially stolen and misappropriated money to further their own business, and it was done on social media. And the BNI group redressed their standing based on this.
So
These are all facts alleged in the complaint.
those are facts that are contained within the background of the complaint, of the amended complaint. And
It may not be an artfully drafted complaint.
correct.
It would certainly have been better for these to have been alleged separately, but under Rule 8F, do you have a case that says that we are required to ignore what's in this introduction as a matter of law, or put another, because that's what we're dealing with. We're not dealing with a discretionary decision here. We're dealing with an issue of law, and there is an allegation of misappropriation of funds, which would be defamation per se.
Okay, but she's not pleading defamation per se, she's just pleading defamation. And within
Does she
this-
have to in a complaint? Isn't it enough to just say this is defamatory?
I don't believe that it is just enough, because I believe that if I have to answer on behalf of my client, if this is the procedure by way of which we come before the court to file motions to dismiss and otherwise, I have to have something to go off of. I can't go off of that, my sister, for example, I'll just use a hypothetical. I can't go off the notion that Johnny says that I allegedly stole money and I defamed him in my complaint, and then go down and talk about an unpaid frozen bill through the duration of the complaint, and then have that survive. That's why I filed the 12b6, was there were all of these alleged statements that my client was making that were defamatory, but there was nothing to hang my hat on by way of an argument, or even by way of an answer for that matter. I would have had to plead out.
You could have moved to have it struck as not clear.
Correct.
But then, that wouldn't have been with prejudice. 12b6, failure to state a claim, is with prejudice.
Correct.
So for that, we have to find that there's no facts in here that make out the tort.
Correct. But in this case, she dismissed it without prejudice, and she didn't look beyond the four corners of the complaint, and therefore she didn't take into account anything. And in fact, there's, if you can turn to my record appendix at page, sorry.
Wait, you saying this was a dismissal without prejudice?
It was dismissed without prejudice.
Where's that?
That was actually the finding by the court at the end of the ruling.
It says dismissed, it doesn't say without prejudice, at least that I can see.
Yeah, I don't see without prejudice either.
Yeah, I don't either. And a 12b6 is always with prejudice. Let me approach this a different way.
Sure.
I believe one or both of you have cited the Maram case, which points out that under Rule 10C, we can consider on a motion to dismiss a written exhibit which is a written exhibit to a pleading, or matters which can be judicially noticed, or other matters of record in the case. The original complaint in this case, I'm looking at footnote 4 of Maram versus Kobrick. The original complaint in this case alleged in count 1 that the funds were stolen. Are we permitted to look at that original complaint?
I would say no, because at the time that I was arguing from the amended complaint before Judge Howe on the record, I had attempted to bring back in the original complaint to show how vastly different the two complaints were from one another, and I was not permitted to, as the amended complaint was the new complaint, which should have the same facts within the averred facts that would have flowed through. There was changes of names in the amended complaint. There was also changes of counts from the original to the amended, and some of the facts within, I had, at the time that I was going to be arguing that, was not permitted to argue it because the amended complaint was to be held as is.
The other aspect of this is that the social media post was, which is at record 93 to 94, was later supplied. The motion to supplement was denied. But footnote 4 of Maram also says that a judge may consider extra complaint material so long as everybody's on notice.
Correct. And I'm glad.
So I think my question is whether or not, as a matter of law, it's one thing to say there's no allegation in the complaint. It's another thing to say there are no facts. And we're sitting here with this document in front of us that talks about stolen funds. So what are we to do with that?
Well, Your Honor, I don't think it says stolen. I think that you can take it at face value, or you could take it through interpretation, or you could take it as I had argued in my memorandum of law in the first motion to dismiss, that it is an opinion, right? I mean, here you've got.
Well, that's a question of law that we can talk about. I'm just stuck on what are we permitted to consider at the moment.
So this particular court has stated that as long as there's no surprise element between the parties about it not using the materials outside of the four corners of the complaint, that as long as the judge is giving notice and noticing us that she's only going to be continuing to only look at the four corners of the complaint, that's sufficient. And also, this particular judge didn't do it just once. She did it twice on the record, actually, by way of telling us that she's not going to consider anything outside of the four corners of the complaint.
Well, that's for purposes of summary judgment, which would have required verification.
Right.
But for purposes of a motion to dismiss, an unverified document appended to a complaint would have been fine. What we have here is an unverified document appended to a pleading and a rule, which is 10C, which says we can consider other matters of record.
Correct. And I guess I understand now where there may be some confusion coming about the motion to dismiss with prejudice versus not prejudice. And it actually comes at record upon, on the transcript. I'll point you to Appellee's Appendix number 2, T43 at number 22, and it says, I'm going to treat this as a motion to dismiss and not as a motion for summary judgment, which I would presume would be a motion to dismiss without prejudice.
No.
Why would you presume that?
Because if it was a motion for summary judgment, that would be with prejudice,
But at
correct?
12b-6, failure to state a claim is with prejudice.
Okay, great. So then with respect to that, then we just fall back on the pleadings alone, and then we have issues of causation. We'd also have to show issues of damages, but we don't even get there either.
Can't you consider documents that were relied on in framing the complaint?
I'm sorry, can you repeat?
Can't you consider documents that were relied on in framing the complaint, such as the texts that appear in the record?
You could if you actually referenced that there was in fact a text. There was not even a reference of the text even within the background. It was something on social media. It didn't even say where it was, didn't say what it was.
Well,
It didn't, I mean,
But Rule 9 of the Rules of Civil Procedure requires pleading with particularity for fraud, misrepresentation, and standing. It does not, is there a rule of which that I've missed that requires that level of particularity with respect to defamation?
so I would say Rule 8 would require that the pleadings be sufficient so not to create vagueness, ambiguity, and to create confusion, right, while you're reading it. And in this instance, if you're reading through the complaint, if I'm looking and being sued for $250,000 for defamation on a text that's out there, you know, in social media somewhere, I would say that, yes, you have to absolutely plead this with particularity. And I would
Well,
think,
is there a rule or a case that says that? I understand completely why you would have appreciated a more cogent complaint. That's not necessarily the issue, though. It may be, but maybe not. So
I don't have one now, but I would be welcome to supplement the record hereafter with a case if I could locate one with respect to that.
May I ask about your the 93A claim? The complaint alleged that a 93A demand letter had been sent.
Correct.
If that demand letter had been attached to the complaint, would you agree that the allegations in the demand letter would essentially be incorporated in the complaint and could be considered in deciding whether the complaint stated a claim?
I think that that's a fair representation that it could be incorporated.
Okay,
certainly.
so what about when the letter is not attached to the complaint and it's merely submitted by one party or another in connection with other papers on the motion to dismiss, and the judge can consider that? Is the judge obligated to consider it?
I don't think that the judge is obligated to consider it if the plaintiff doesn't incorporate it into the complaint, because without seeing it or having a reference point to it, in this particular instance, the complaint stated that there was a 93A violation by way of, you know, my client's business. But you have to, I think the way that I had viewed this complaint in its totality was to take the complaint at face value. It's a defamation claim. It's an intentional infliction of emotional distress. It's a 93A claim. But when I looked at that, I also had to look at who were the plaintiffs in this case. Was it a business or was it an individual? And then I also had to evaluate it, given the fact that it's a defamation claim. I'm looking for statements, because not even in the 93A claim, or 93A letter, even in my response back to the 93A letter, there was the same issues relating to, there wasn't what the statement was, when it was made, how it was made. It was just this loose allegation of stealing money, but my client never stole the money, and there isn't any proofs, there's no facts to hang on to the pleading, there's no causation, there's no damages. I mean,
Right.
it's...
Your red light is
Sorry.
blinking,
Thank
and
you.
I have one very
Sure.
brief question, which is, I take it that your client is a for-profit corporation, not a nonprofit corporation?
Correct, yeah.
Okay, thank you. Any further questions from the panel?
Thank you, Your Honors.
Thank you both. All right. The next case is 22P0627 Woods versus the Hanover Insurance Company. All right, Attorney Weber?
Yes.
You may begin.
Excuse me. If it pleases the court, Marnix Weber for the appellant Kimberly Woods. We are asking this court to overturn the entry of a summary judgment based on a statute of limitations issue. The order by the judge in the underlying case states that all the parties agree that November 29th, 2020 was the applicable statute of limitations for the appellant's 93A damages claim. I believe both the appellant and the appellee disagree with that decision, as pointed out by my brother's brief as well as my own. I believe we disagree with that decision for differing reasons. I asked this court to look at the International Mobiles Corporation case, which I believe is the guiding case.
Sure, but that was a negligence action against an insurance agent for failure to place coverage. So, of course, that wouldn't have accrued until it became clear that the liability was greater than the coverage that actually existed. I don't see why that's relevant to this.
Well, so it's the discussion of when actually a 93A action accrues, and it points out the accrual date for a 93A cause of action is determined by the same principles dispositive of accrual dates of general tort actions. So in a tort claim, you need both cause as well as damages.
So when were you first when was your client first damaged by what you say was the failure to make a settlement offer once liability was reasonably clear? What was the first damage?
Well, arguably, we've pled a number of different dates. There was the various dates of depositions of the underlying defendant where admissions of liability were made.
Okay, but tell me, what was the damage that you suffered and when did you suffer it?
Well, so the damage that we suffered is unknowable until the actual date of the settlement. In 93A cases,
Why is that?
Well,
Why is that? I get it when there's been an insurance claim and the plaintiff is underinsured as of the result of failure to place coverage. But your complaint alleges, for example, that liability was reasonably clear the moment she fell.
Well, so you're correct, Your Honor. We allege a number of different dates where we believe upon, or we plead upon information and belief when we think that the insurer could have known that liability was reasonably clear. That is what we have to show in order to succeed on the merits in a 93A case. When we're discussing the statute of limitations on a 93A case, we believe it should stem from when the plaintiff actually knew or when her damages actually accrue, which is not actually until the date of a settlement or a judgment.
I don't understand why there weren't damages on August 16th, 2016.
I'm sorry, could you say that?
I don't understand why there weren't damages on August 16th, 2016.
Well,
There aren't much damages, but I don't understand why there aren't some damages on that day.
Well, that it's unknowable whether or not there are damages on that day.
Well, how's it unknowable?
Well, if the case-
Liability was clear, and on August 15th, 2016, Hanover says, we're not paying you anything. And so by the next day, when you don't have money with liability clear, you've got damages, right?
Well, not necessarily, Your Honor. If,
How would you not
we
have
had
damages?
proceeded in the case and ultimately gone to trial and lost, and there would have never been any damages, and we would have never had a claim to begin with.
You mean if it turned out that liability wasn't clear because you had a loser, that therefore you wouldn't be damaged at that point?
There would be no damages because our claim would have failed.
Do we really do statute of limitations by asking ourselves, what if everything alleged in the complaint is false? Then when does the liability become clear? When does it accrue? Or can we take the complaint as true?
It's a little bit in a for instance, a general tort action. You know, you have an injury, you have medical bills, you have loss of wages, you have
Yeah, but I've never seen anyone in a tort claim say, well, my claim didn't accrue because I might have lost and the jury might have found that the defendant wasn't negligent, so therefore not until the jury found the defendant negligent did I have damages and therefore my statute of limitations start. I've never seen anyone make that argument.
Well, so it's separate in a 93A claim because the damages, the specific damages are loss of use of the money that should have been offered, right? So you can't know what the loss of use on the money is until there's actually some type of settlement or judgment.
Verdict.
Thank you, Your Honor. Or verdict. It's different in a general tort claim or a contractual claim where it's knowable because you have at least some modicum of factual basis for your damages.
Well, what if you send a demand letter to the insurer laying out all the medicals, saying you've got 10 affidavits from the insured's employees acknowledging that they didn't shovel the walk that day and they knew it was intended to get icy, and you lay out the complete picture of liability and damages, and they make no offer. Then you end up going to trial, and somehow the plaintiff doesn't show up for the first day of trial, and the judge dismisses it for failure to prosecute. You end up with no settlement or judgment. Are you saying that you would have had no claim against the insurer for no damages? Does it really depend on the ultimate result of the underlying case?
I think it would, Your Honor, because I don't know that you would be able to proceed with the underlying claim if you have, or with the 93A claim if you have ultimately lost the underlying claim.
So does that mean that you can't resolve one of these 93A 176D claims unless and until the underlying claim has been resolved, whether it's by judgment, settlement, dismissal, with prejudice, perhaps?
Well, any of this is negotiable behind the scenes by competent attorneys who can look at their own files, and this kind of raises a big issue for us.
But I'm asking whether it can be litigated. Can you litigate one of these claims?
That's a good question, Your Honor, and I think the answer is, for the most part, these cases are not litigated until the underlying claim is actually settled. In most instances where a 93A 176D claim is filed at the same time as the underlying claim, those claims are stayed and severed until the resolution.
But isn't that weird? Because you're telling us that you shouldn't have made the claim at all. Like, how can it even happen? If you're right that you don't have a 93A claim until the underlying case settles, then how can we have cases where people make the 93A claim and the underlying claim at the same time?
Well, you have the, and this points out kind of the imbalance between the parties here. The plaintiff versus the insurer in this case can never actually know what the insurer is thinking behind the scenes, what their files say, what kind of liability determination they're making within their own files. They'll never have access to that until they actually make and file the 93A lawsuit. And that's why these claims are typically stayed and severed, because what's in those files is usually work product privilege materials until it just becomes about the 93A claim. So you make the allegation of the 93A 176D violation upon information belief, but you won't actually have the facts and the evidence until you get into discovery on those.
You did originally make that allegation, and then that claim was dismissed from the complaint, as I understand it.
It was withdrawn. There was an agreement between the parties.
Does it matter why it was withdrawn?
I don't believe it does matter in this instance why it was withdrawn. If it had stayed in the case, then there would have likely been a motion to stay and sever. I don't know that hypothetical actually affects the outcome of this case, but it was withdrawn. Had it stayed, likely that would have been litigated after the underlying issue.
If it hadn't been withdrawn, then we wouldn't be here today.
Probably not, Your Honor.
So you originally raised this claim before it accrued? Is that what you're saying?
We're not making that argument, Your Honor. We did file 93A 176D actions against Hanover Insurance as part of the underlying claim, but we did withdraw that, and we did settle that underlying the underlying claim, not the 93A 176D action, which brings me to another point is that in the settlement of the underlying action, we specifically bargained for the right to bring the 93A 176D claim. My brother,
But there's no tolling agreement.
Well, Your Honor, we didn't believe that there was any imminent statute of limitations issue.
Understood.
Yeah.
But there's, the agreement doesn't address this issue, though.
It doesn't specifically touch on the statute of limitations. It does say that we reserve our right to bring this claim, and they reserve their right to defend the claim.
Right. So I just have one question about your complaint. I read your complaint, your 93A complaint, to be based solely on unfair claim settlement practices by virtue of delay. I do not see an allegation there of an inadequate investigation. Is that correct?
I believe that is correct, but we, hopefully we'll have the option to litigate the case further, and if we do discover.
Well, but for purposes of this motion and this record, I'm not asking you to waive anything in the future. We are looking at what is the appropriate statute of limitations for purposes of an unfair claim settlement claim.
Yeah.
Based on unreasonable delay in proffering funds when liability was reasonably clear.
That's correct, Your Honor.
And you allege that both that liability was clear at the time of the accident, reasonably clear at the time of the accident, and that during the course of discovery, you would say it became clearer.
Well, we allege a number of different potential starting points, one of which being at the time of the accident.
If you say one of the starting points is at the time of the accident, why does that not bind you for purposes of the statute of limitations?
Well, there's two reasons. The first being the argument that my client doesn't really have a claim until her damages actually accrue. The
Right,
second,
we've discussed that.
yeah, which we've discussed. The second would be application of continuing violation
Okay.
doctrine. And essentially, if the argument my brother puts forward is that if after the answer of a 93A letter starts the clock, then the insurer essentially has an incentive now to stretch this case out for more than 4 years, which in this case it essentially did. And any new violation or any subsequent determination that liability and damages are reasonably clear on the insurer, they essentially get off scot-free for that, because they've answered.
You seem to be asserting that each new bit of information that the insurer acquires might trigger a new duty to make a reasonable settlement offer once, even if the prior information wasn't sufficient to make liability reasonably clear. Let me ask the question this way. You send a demand letter laying out your case. The insurer refuses to make an offer. So putting damages aside, your position would be you've got failure to settle where liability was reasonably clear. If you send another letter just like it a year later, but maybe fixes some typos, and they reject that, you don't argue that starts a new limitations period running. You don't argue that that's a new claim, I assume.
Potentially under the continuing violation doctrine, if the insurer does another review of the claim file, right?
Okay, I'm getting to that.
Yeah.
I'm getting to that.
Okay.
But you agree that just sending another letter that's essentially identical doesn't trigger a new claim?
No, not necessarily,
All right.
Your Honor.
So how do we decide how much different the new letter has to be, or how much new information the insurer has to have in order to trigger a new claim accruing?
Well, that's somewhat unknowable without the ability to conduct a discovery on that issue, and which is essentially what we're asking for here, is the ability to do discovery and find out at what point exactly did they determine that liability was reasonably clear or damages was reasonably clear. And it kind of dovetails back to what we've kind of discussed ad nauseum about my client's damages not accruing until there was actually a settlement. But once my client has damages, because she's gone from a $0 offer to a six-figure settlement, where nothing in the case has changed since the end of discovery, I think at that point she finally learns that she actually has damages here. So,
just getting back to the liability point, though.
yes.
You say you need discovery to determine when liability was reasonably clear. This was a summary judgment motion. Is there anywhere that you filed a 56F affidavit or otherwise made clear to the court that you needed more discovery to determine when liability was reasonably clear?
Well, this wasn't necessarily, it wasn't a Rule 56 motion on the merits of the case. It was a Rule 56 motion on the statute of limitations.
Sure, but it was a Rule 56 motion that threatened your entire case. So if you needed more facts to establish when the claim accrued and therefore when the statute ran, didn't you need to let the judge know you need more facts, you need more discovery?
Well, I believe we did argue that there would be, we did argue the point that the continuing violation doctrine would apply here, and under the continuing violation doctrine, that each new instance may reset the clock, and that we haven't had discovery in this case, and therefore we can't actually show that.
Okay,
I
but
believe that was argued.
you didn't say this motion for summary judgment is premature, or we can't respond to it because we don't have the information. Therefore, please give us more time to conduct discovery on such and such issues.
I'll concede not as specifically as you've put it, but I believe that we have argued that in essence.
Any further questions? All right, seeing no further questions, thank you both.
Thank you.
Or thank you. We will now hear from counsel.
Thank you, Your Honor. And may it please the court, my name is Brian O'Connell. I represent the Applee Hanover Insurance Company, and I'm here asking this court to affirm the Superior Court's decision that this claim pursuant to Chapter 93A, Chapter 176D, 39F, brought by the plaintiffs more than 4 years after Hanover's response to what the plaintiff's purport is a demand letter, is untimely under the statute. First, Your Honor, you had, Justice Ditkoff, you had stated that my brother stated the date of there was a response from Attorney John Bruno, who represented the insureds in the underlying case. Hanover's response to the June 27, 2016 letter was received by the plaintiffs on July 25th, 2016.
Sure, but that letter just said someone else is supposed to pay, and we've contacted them, and they haven't responded yet. I don't see why you've got a 93A case.
Your Honor, that claim, that response by the carrier stated that under the facts presented, liability wasn't reasonably clear, and there wouldn't
But
be.
the only reason for it was because Taylor Lumber is supposed to pay. We've contacted their carrier. They haven't responded yet. I don't see how you could raise a 93A claim on the grounds that they're contacting a insurer who has a senior duty to compensate.
Your Honor, that was in response to what the plaintiff's claim is the 93A letter. But even if you want to go with the later letter from Attorney Bruno, the claim is still untimely. So that's fine. Respectfully disagree, but you're the boss in this regard. But the claim is still untimely.
I'm not the boss. Jim Sullivan's the boss.
Oh, no.
You're the panel of bosses.
It's a tripartite boss.
Well, the matter is still. Respectfully, I believe, Your Honor, I think that the record shows that the claim is still untimely if you want to use the Attorney Bruno letter that was received, I believe, on August 15th. But getting to the heart of accrual in this case, respectfully, my brother and my opponent, Mr. Weber, my friend as well, he's dead wrong on this issue of when a claim accrues. You don't have to have the even specific damages suffered for a claim to accrue.
But you have to have some damages.
Correct, Your Honor.
What were the damages earliest suffered?
Sure, Your Honor. You know what?
When was that?
The Supreme Court, the SJC says it better than I, and it's in the Hopkins versus Liberty Mutual case. Actually, in preparing for today, I realized I hadn't cited the full case. I cited the mass case, then directed right to a page. So I apologize to the panel and to the smart folks to my right who probably had to find the case. It's in the Statement of Authorities. In the Hopkins versus Liberty Mutual case, Your Honor, the court stated that even if a case settles later on, a plaintiff in a 176D39F, which is that's the only case here, suffers harm on the loss of use of money when that's not offered. That there's harm at that point. If there's a demand.
But how does the plaintiff know that any loss of use of money has occurred until the plaintiff knows whether some money will be forthcoming, whether through judgment or settlement in the underlying case?
Your Honor, within that 93A case, in my opponent states you can't do it, there are 93A trials that deal with, under the Hopkins analysis, was liability reasonably clear and what were the amount of damages? For liability to be reasonably clear, both liability and damages must be reasonably clear. And so that is the
damages
93A
trial. Damages to the plaintiff from the underlying negligence. We're talking about damages from the failure to make a settlement offer when liability is reasonably clear. When do those damages first occur?
Sure, Your Honor. They first occur when there's a failure to make a reasonable offer for a settlement, when liability and damages are reasonably clear, as the plaintiff's alleged. Now, you wouldn't need an ultimate decision by a jury or even by a settlement if the trial of the 93A case is what facts were presented at that point, were liability and damages reasonably clear? What was the amount of settlement that should have been offered? In fact, in 93A trials, there are experts that testify on this issue. And then just using the Hopkins analysis, Your Honor, you go back to the date of the denial. Okay, what's the loss of use of that? If it was recovered later on via settlement or judgment, then the damage is a loss of use or interest. That's how you determine. They determine within the 93A case.
But if there's never a settlement or judgment in the underlying case later on, can you still litigate a 93A claim against the insurer and say, if we had negotiated this, or if it had been tried, I would have obtained at least such and such as a judgment or settlement. You should have offered me that back in August of 2016.
Sure, that would be tried. I'm sorry, did I cut you off? I didn't mean to.
I'm trying to get a handle on whether one can know anything about whether there are even damages before the resolution of the underlying claim.
Yes, you can. I mean, based upon what the plaintiffs alleged themselves and what they presented to the carrier, they were saying liability was reasonably clear and their damages were reasonably clear as of June 2016. So at that point, based upon what's been presented to the carrier, the issue is, was liability and damages reasonably clear, and what's the value of the claim? If there's a resolution later on, I agree, the damages are the loss of use of that money, the interest under the Hopkins
But if there's
case.
no resolution later on, then what are the damages?
There's no resolution later on, there'd be an independent determination of what should have been offered at that point, and that's what the 93A case is about.
Is there any case you can point to that does that?
Your Honor, no, I honestly, Your Honor, with respect, I can't point to a case where an underlying case is never resolved by either judgment or settlement. So I don't think that contingency would ever come up, that there's never a resolution of an underlying case. And mechanically, what often does happen is the plaintiffs will bring a 93A claim at the same time as as one of these claims, and as my brother stated, they're often severed as state. And as you stated, Your Honor, if that was the case in this case, that we probably wouldn't be here. The case would have been filed. Plaintiff ostensibly would have been gaining interest, statutory interest on that case, but that's not what happened. They dismissed it and then rebrought it more than 4 years after the accrual.
Let me approach this from a slightly different direction, and correct me if I misstate this. But would it not have been a defense to the 93A claim to claim a reasonable but mistaken belief that no settlement offer was required?
Your Honor,
Is good faith a defense? Let's just
Sure.
put it that way.
Well, good faith is a defense, yes. I think under the Hopkins case, the court there talked about a more objective standard, what was known to the carrier, what was a reasonable settlement offer at that point.
So
it kind of takes the subjective out of it.
Fine, but objectively reasonable but good faith. So let's take that test. So the plaintiff sends out a letter, they get a response received on August 15th, which is a Saturday, by the way, so that's interesting, somebody was working on Saturday. And then they go out and do discovery. Does the plaintiff really know at that point that the good faith defense, to cut it with a short label, is applicable, or do they actually need to go out and conduct discovery? Because the allegations here are that the discovery in 2017 and 2018 informed the plaintiff that there was no good faith belief, objectively good faith belief. Do we really want to tell plaintiffs they have to sue the minute they get the 93A response? Or do we want to make sure, in the usual case where there'd be a stay or a follow-on, that some kind of discovery takes place before this issue is joined?
Well, Your Honor, discovery wouldn't happen first of all, severing and staying, discovery wouldn't happen in a 93A claim. But
It's true, it wouldn't happen until after, but it might have happened just in normal discovery. This could have come up in normal discovery of the negligence claim.
But, Your Honor, even in any case, or in many cases, say a regular bodily injury case, when someone, let me back up for a second. You see, do we really want plaintiffs to bring these suits? The legislature's already decided when the suits have to be brought. They have to be brought within 4 years of accrual of the action.
But we're talking about when is the accrual.
When is the accrual?
And does accrual contemplate the defense?
Okay, and if I can cite this court for a second, the International Mobiles case, and I think this does in part answer your question. The court in International Mobiles said that some degree of harm came to the plaintiff as a result of defendant's negligence, in that case it was the insurance agent, is all that is required. The extent of the injury need not be ascertainable at the time of accrual of the action. So it just has to be some damage.
Understood, but if good faith is a defense,
Right.
then does the plaintiff not, for purposes of accrual, do we have to consider that defense, or do we only consider the cause of action?
You only consider the cause of action. Say, Your Honor, in a negligence case, if comparative negligence is a defense, right? The defendant in that case still has that burden to prove the affirmative defense, but it doesn't have to be disproved before the plaintiff has a cause of action. The plaintiff has stated in
I don't get that. What if you have, car accident, and plaintiff says, defendant was at fault, defendant said, no, plaintiff was at fault, and you'd go and litigate it, and you'd think the insurance company for the defendant was being perfectly reasonable, not offering a settlement because it's he said, she said, and jury's going to believe one of them. And then you find out late in discovery that the defendant has has announced that he was lying and that it was all his fault. And then at that point, that's the point at which you'd know the insurance company was being unreasonable, and you'd have a 93. Why wouldn't that be the accrual point in that scenario?
In that scenario, yes, that's when, but here, it's the allegation are that liability was reasonably clear as of this date, and you didn't make a settlement offer. That state of reasonably clear liability, going to my brother's argument about continuing.
But let's just
Sure.
I promise you'll get a
No,
word
that's
in
fine, Your Honor.
edgewise in a moment.
Like I said, you folks are the
Let's
bosses.
take the August 15th date. Let's say the plaintiff gets the letter, but then in discovery, it finds out that whatever the defense is that's asserted in this response letter was not only untrue, but the insurer knew that it was untrue because these were the employees of their insured or a co-insured or whatever. Doesn't that matter?
Your Honor, for the purposes of motion for summary judgment, plaintiff is bound by the allegations. Okay, and here, as a matter of fact, we have the plaintiff alleging liability is reasonably clear as of this date. We're at the point of your hypothetical.
I know, but I'm asking you to think about the discovery, and let me see if there's an example here. The landlord would have been responsible for maintaining the walkways. You could say it's all disputed. I mean, there's a lot of allegations in here in 2017 and 2018 as to who was responsible for the walkways.
Right. So, but Your Honor, again, the allegation sets forth several dates, and then it sets forth later dates as well. But once liability is reasonably clear, that's the accrual date. That's what the case law shows us, the Hopkins case. It starts then. These might be, that's really just a continuing injury that the Mack case and the Montefiore case talks about. Once you hit that state, I'm calling it a state of reasonable clear liability, like it's nirvana or something, but it's a state that occurs, and one of the examples I'm going to say, someone's dead, then they're more dead. It's a little bit more macabre. But once you reach that state, that's the accrual date, Your Honor. You've suffered an injury, and it's really, honestly, Your Honor, really no difference when you suffer a bodily injury because of someone else's negligence. The plaintiffs allege that they suffered an injury upon the date there was reasonably clear liability, and there wasn't a response. There wasn't a reasonable offer. And just these allegations of additional status, okay, it's reasonably clear now, it's reasonably clear now. In that case, it's really never, the statute of limitations would be meaningless. There is an accrual date. It might be different from ultimate liability, Your Honor, but that is the accrual date for the purposes of the statute of limitations, which was the only basis of the motion for summary judgment. Also, the court touched on it, this idea of the release. My brother doesn't cite the entire release in the body of his memorandum. At the time, it does state that.
See, there's nothing there specifically about limitations.
In Hanover states, we reserve our rights to defend and deny any liability. And also, that was signed, I believe, on October 1st. Respectfully, I don't understand, we might have different dates as to which was the response letter, but either one, there was still time with that period as well, if the plaintiff wanted to bring a claim, he still had over a month to bring a claim.
Just a very technical question. You insured Curtis, not Taylor, and not Pro Sports?
Correct. We Hanover insured, I believe, 2 of the defendants, Your Honor.
Did you insure who insured Pro Sports? Was it you or someone else?
It was somebody else.
Okay.
It was somebody else. Well, I'm about to be blinking. Is there any other questions, Your Honor?
Any other questions? Seeing none, thank you both.
Thank you, Your Honor, very much.
All right, the next case is 22P0675, Bugsby Properties LLC versus Alexandria Real Estate Equities, Inc. You may proceed.
Thank you, Your Honor. Good morning. May it please the court, my name is Phil Brown, and I'm here on behalf of the plaintiff appellant, Bugsby Property LLC. And I'd just like to take Justice Sullivan's statement at the very beginning to just get to it. And in looking at this case, I'd suggest that there is one way to take a look at it, and it's really sort of dispositive of the issue, and that is that this is not a contract case. The claim in this case is for quantum merit. There's no real dispute as to what law applies to determining choice of law in this case. Both parties agree that the restatement of conflicts, Section 142 applies. It's been well stated in a series of cases. And the one that I like the best is the Goudreau case, where it states that the focus should be on the state which has the most significant relationship to the occurrence and to the parties with respect to the issue of limitations. The point of a quantum merit claim is you have a detriment to one party as a result of the acceptance of something from the other party. The elements of a quantum merit claim are different from a contract claim. There's no element of acceptance, there's no consideration, there's none.
Why weren't the elements of the quantum merit claim complete when the Bugsby blueprint was presented in 2013 or so, was it, late 2013? And then I think as alleged at pages at 40, 25 of the record appendix, first record appendix, ARE recognized that Bugsby's advice had great value, but after it received it, ARE sought to avoid Bugsby's reasonable expectation to be paid and credited. And we're talking about late 2013 here. In response to Bugsby's requests for compensation and credit, Joel Marcus used a series of heavy-handed tactics against Stephen Marcus in an effort to permit ARE to wrongly and unjustly keep the value. And that began apparently on December 27, 2013, when ARE sent the confidential non-disclosure agreements. So why didn't the conferring of the value and the refusal to pay for it occur in late 2013?
Because also pled in the complaint is that the payment or the obligation to pay only arises if there is a success. And that's in, I believe, paragraph 26 of the complaint.
But it says in paragraph 42, Bugsby's reasonable expectation to be paid and credited. And Bugsby's, in response to Bugsby's requests for compensation and credit, Joel Marcus used a series of heavy-handed tactics beginning in late December 2013. Aren't you bound by that allegation in your own pleadings that you made requests for compensation and credit and had a reasonable expectation of being paid as of December 2013?
we also, I don't think that we are bound solely by that allegation, because we're also bound by the allegation where we allege that you're not entitled to be paid until there's a contingency.
You may also have expected more compensation later if the advice was implemented and was successful, but you don't need to know the full extent of your damages in order to have your claim accrue, as long as you know you've been damaged in some way. As soon as you weren't paid for that advice, why didn't the claim accrue?
Well, you could look at this also as a continuous accrual, where it may be that that particular claim, based upon what he was asking for in 2013, might be barred, but that the claim that he's entitled to, that Bugsby is entitled to payment as a result of the 2015 and the 2019 transactions, those claims actually don't accrue until the contingency has occurred, which is that there is a success. There was a successful transaction.
Did Bugsby give new advice? Or wasn't the blueprint basically complete in 2013?
The blueprint was basically complete in 2013.
Okay, so the fact that Alexandria might be profiting from this strategy into eternity doesn't give Bugsby a new claim, a new cause of action every time Alexandria implements it and makes money on a new deal.
I would suggest, actually, Your Honor, that it does. That just because
Well, there's no agreement for royalties here.
We're not talking about royalties, though, Your Honor. We're talking about they are using the advice. There is a successful transaction. The contingency occurs, and actually, under Lis v. Studeni, the SJC has said that a cause of action for quantum merit accrues upon the contingency. That's a case, in fact, that involved an attorney seeking payment on a contingent fee, and in that particular case, the contingency did not
There was
occur.
no express discussion of a contingency, even alleged. There's an allegation that you reasonably expected, you meaning Bugsby, reasonably expected compensation once the strategy was implemented successfully. But you also say you reasonably expected compensation right after the blueprint was delivered.
Well, you can have expectations to be paid at one point, and if you're not paid then, you could certainly have an expectation to be paid later.
Sure,
I don't
but your
think one
claim accrues the
negates
first
the other.
A new
time.
claim accrue, does it?
Sorry. Same question, but your claim accrues the first time, right?
If the claim accrues the first time, it doesn't keep the claim from not accruing the second time. And we're not alleging that we're entitled to compensation from the first time. What we're alleging is that when...
But you were alleging that. It says that you expected compensation back in December 2013. It's right in your complaint.
But we're also alleging that we expected compensation when there was a successful transaction. And so I think, you could look at it as potentially pleading in the alternative, but I don't think you have foregone the right to have a quantum merit claim accrue in 2015 simply because someone refuses to pay you in 2013.
Can you explain to me the importance of the 2019 transaction? I mean, what theory here gives you a right to be compensated anew each time there's a transaction?
Well, if you look at California law, there's certainly a continuing accrual theory under California law.
But that would assume that you were deprived of something anew on the new transaction. But it seemed like your theory was that once the Bugsby blueprint had worked, you were then at that point entitled to the value of your services.
Correct.
So why does it matter that it worked again?
Because you're also entitled to the value of the services on the second time that it works. It's not as if you are entitled
Why would you get
just
quantum
once.
merit at both points? Why wouldn't you just get quantum merit the first time?
Because you would be entitled to quantum merit the first time, but you're also entitled to quantum merit the second time because they're still using the blueprint. It's alleged that they're still using the blueprint to continue to successfully create transactions.
So if in your view, if ARE was acting properly, what would they have paid you and when?
They should have paid Bugsby in 2015 or 2016, shortly after the transaction had closed. And they should have also paid after the transaction had closed in 2019.
And paid you what?
That's why it's a quantum merit claim. There was no agreement on what the actual amount would be, but it was considered to be consistent with what the sort of terms of transactions and payment that he received back in 2008.
Let's pretend this Bugsy blueprint, the value of the services there is worth $1 million. So if that's the case, I know I'm making that number up. It's a totally made up number. What do they have to pay you in what should they have paid you in 2015?
If it's determined that the blueprint, well, it's not what the blueprint is worth, it's what both parties appear.
Not just the blueprint, the work that was done.
The work was done. If it was $1 million, then they would be entitled to, they were entitled to the payment of what it was worth in 2015 as a result, $1 million. And it is still, but it's not a one-time
And then in
transaction.
2019, what would you have had? They pay you $1 million in 2015. What do they owe you in 2019?
I'd say that they still owe you another percentage of what that transaction was, because that's what the deal was.
I don't get this idea. If I give you a hammer with the expectation that you're going to pay me for it, and then you go out and make a living as a carpenter, do I get some percentage of every payment you earn as a carpenter for the rest of your life? I've given you a tool. What you owe me is the value of the tool in a quantum merit theory, not the value of everything that you do with the tool.
Well, I agree with you, Your Honor. You would not owe me.
So how is the Bugsby blueprint different from a hammer?
The Bugsby blueprint is different from a hammer because what the expectation was is that there was going to be a continuing payment on transactions. So that, for example, if you're helping someone with a transaction, and even though you've already given them information for it and it's continuing to be used, you're still entitled to the percentage that of that transaction.
And who sets up that rule that you're entitled to be paid for each transaction?
Well, I believe that's what the
There's no explicit agreement.
there's no explicit agreement, but that's what Bugsby understood it would be paid based upon prior transactions or prior work that had been done with ARE.
Between Bugsby and ARE?
Well, between Stephen Marcus and ARE.
Where's that in the complaint?
I believe it's in it's in one of the first few paragraphs. I don't have it off the top of my head. In any event, if you look at when a claim accrues, and if you take that a claim accrues upon the contingency, in this case, the claim would have accrued in 2015. And so how did it accrue? It accrued as a result of the transaction. And because the transaction involved Massachusetts property based upon a business that has a significant presence in Massachusetts, then Massachusetts law should apply. Massachusetts has a substantial interest in ensuring that people who help with transactions get paid. And that's expressed in the statute of limitations for quantum merit, which has a 6-year statute. It's expressed in the fact that there's no borrowing statute from another state. And it's expressed in the fact that a company that is doing business here should have a reasonable expectation that it's going to be subject to Massachusetts law. The fact of where a initial meeting was, and that's really that and the fact that Alexandria has a principal place of business in California. Those are the two items upon which the trial court really hung its hat in terms of finding that the occurrence, that's where the occurrence was. We'd suggest that the occurrence actually occurred when the contingency was met and when the first transaction closed.
Is there any evidence in the record as to when your client knew of that first transaction closed?
There's no explicit allegation as to when, there's no explicit allegation as to when the client knew that the transaction closed. It is true that it was in a public filing. Whether or not there was a duty to monitor the public filings, that would be a question. But no, there's no allegation that says that he did not know as of.
In this posture where it's being decided on affidavits, why don't you have to have an affidavit saying, I didn't know and I couldn't have been expected to know because of X, Y, and Z to raise that claim that he shouldn't have known until 2014?
Well, where you're doing this, first of all, this is a motion to dismiss under 12b6.
Was it though? Both parties presented affidavits and argued from the affidavits, and you do that in your brief as well. Why wasn't this a conversion to summary judgment just on the choice of law, statute of limitations issue?
Certainly, the judge did not convert it to one for summary judgment. The judge dismissed it as a 12b6. That's a very good question, Your Honor, and it could go back to what you were arguing or discussing in one of the earlier cases is, are things that are included or referenced that are potentially outside of the record able to be considered on a motion to dismiss. And I'd suggest that, yes, they can be.
They can be why?
Because the SJC has said that when you reference things in a complaint and you need to make them whole, you can look at the whole document.
That would not apply to the question when your client knew that the sale had closed.
That's correct.
Are there any other questions from the panel?
Thank you, Your Honor.
Being none, thank you very much.
Your Honors, Randy Mastro of King & Spalding on behalf of Defendant Appellee Alexandria. I think Your Honors have already cut to the heart of the case. I heard the following admissions by my worthy adversary during his argument. I heard him admit that the blueprint was basically completed in December 2013. I heard him agree there was no agreement, royalties, to recur every time a joint venture happened in the future. I heard him agree that could have had an expectation of certain compensation in December 2013, but the argument being made that every time in the future there was a joint venture, somehow they were entitled to re-up, or as he referred to it, a continuing accrual theory under California law that the California courts in this very case have already rejected as inapplicable to this case. So I respectfully suggest to Your Honors that on the face of this pleading, that the Superior Court got it exactly right.
Well, on the face of this pleading, I don't know how we get any of this stuff on the face of the pleading. We don't even know that there was a Thanksgiving dinner in California on the face of the pleading. We've got to go to the affidavits for that.
No, Your Honor, we do know, as Your Honors questioned him, we do know that he admits that in his pleading that the work was rendered in full by December 2013. That's on RAI page 25, and some of those aspects were quoted in the colloquy with the court from Your Honors. They admit that the services were fully provided and completed by December 2013. And on that basis, that is when, under either Massachusetts law or California law, the claim accrued. Because under Massachusetts law, Petrucci case, Muldoon, and others all say that at the first moment when you have performed in a quantum merit case the services, when you've provided the work, your claim accrues. At that moment, he admits in his complaint, same paragraphs, that Stephen and Bugsby were told by Alexandria and Joel Marcus, here's your CNDA, you're not going to be paid. Right? So the claim clearly accrued for quantum merit by December of 2013. on the face of the pleading, where they say they fully completed the work in full, provided the services in full, and they knew they weren't going to be paid at that
Does
point.
the CNDA only apply, first of all, Bugsby didn't sign one, right? It was only Stephen.
And yes, Your Honor, and
But does the CNDA only apply to work that's done in the future?
no, Your Honor. The CNDA, on its face, and it's in the record at pages 100 to 103, on its face, there's an acknowledgement there of the work that has been done, and it's to apply to the work that has been done, and there will be no compensation for it. It refers specifically to Stephen in that instance, because it was represented at the time that Bugsby had completed any work it had done and didn't need to sign a CNDA because there would be no further work by Bugsby. That's actually admitted in the complaint. So, Your Honor, it is still the case that even when the CNDA was presented, it was presented and Stephen signed it on the basis that the work had been performed and that there was an express disavowal of compensation. So, Your Honor, I respectfully suggest to all of Your Honors that the Superior Court got it completely right. The 2-year statute of limitations in California law applies. Multiple other grounds on which it could have been dismissed as well, but the 2-year statute of limitations of California law applies on the face of the pleading. Thank you, Your Honors. If there are no further questions.
Wait, why does it apply in the face of the pleadings, the California?
Because, Your Honor, again, and this is on page 25 of the Record on Appeal and paragraphs 43 through 45, there's an express, 42 through 45, there's an express acknowledgement in the complaint that the services were fully rendered and completed by December 2013, and that Bugsby knew at that point that Joel and Alexandria were not going to provide them any compensation.
So why does that tell me the California statute of limitations applies?
Your Honor, the analysis on the done by the Superior Court, I think, got it completely right. For purposes of a quantum merit claim or an unjust enrichment claim, to determine whether Massachusetts statute of limitations applies or another state statute of limitations applies, the rule in this state is a 2-part test under Neerman, whether Massachusetts has a substantial interest in permitting the claims to go forward, and whether another state, in this case California, has a more significant relationship to the parties and the claim. And I think on the face of the pleading, this is an agreement with a company headquartered in California, principal place of business in California, key employees, including CEO in California. It was an agreement made in California to provide the services, and the services were in fact rendered and delivered in California. All that is in the complaint. There is no connection whatsoever to Massachusetts other than subsequently of the many joint ventures that were done in subsequent years. One was in Massachusetts.
Where does the complaint say that the agreement was made in California?
The agreement, the complaint acknowledges that the agreement made between Joel and Stephen for services to be provided was something that was agreed upon in California when Stephen was in California.
Where does it say that?
Your Honor,
I know that's true, but where's it in the complaint?
I will find the reference in the complaint, but it was also part of the record that was put in on the question of the statute of limitations. And there isn't any dispute.
That's totally different. That's kind of what I'm getting at.
I understand, Your Honor. We'll find the reference. It's acknowledged in the complaint that these were services to be provided to
The problem I have,
California entity headquartered in California.
the problem I have is both of you, both here and below, have litigated this, putting in all kinds of affidavits that aren't in the complaint. And so I'm trying to understand why we don't adjudicate this as a converted to summary judgment matter.
Your Honor, whether it is considered summary judgment because on a motion for dismissal on statute of limitations grounds, the court is free to consider verified information or whether you decided as a motion to dismiss. In the complaint, there are many references to these were services being provided to a California corporation headquartered there, principal place of business there, and for the benefit of that California corporation.
You know, one of the reasons why we have Rule 9AB5 of the Superior Court rules is that it's an anti-ferreting rule, and that if you are going to go outside the pleadings, neither the motion judge nor the appellate judges are supposed to be hunting around in the record for which are the facts that are alleged and which are the facts that are properly pled on a motion for summary judgment through verified affidavit. So I would just ask the parties in the future, if you choose to assert matters outside the pleadings, do so in conformity with the rule. The judge would have been entitled to dismiss your motion in its entirety for failure to comply with the rule. Didn't do it, and so we're here, but could have.
But Your Honor, again,
So other than the litigation, the complaint says that ARE has executive offices in California, but it's a Maryland REIT. And other than litigation and talking about the courts, that's the only mentions of California in the complaint.
Your Honor, I'd respectfully suggest that these were not facts that were disputed below. It was not disputed that Stephen and Joel in California reached their agreement for Stephen to do this work. And it was acknowledged by Stephen in many court proceedings.
No,
This
I
is
get
not
that,
the
but
first.
if I start looking at facts that aren't disputed, you presented a whole bunch of facts, and they say basically that everything happened in New York, except for the initial Thanksgiving dinner. Everything. The investor day happened in New York. All his talking to these various investment banks happened in New York. Everything happens in New York except for Thanksgiving dinner. No one's arguing that New York law applies, and I don't know why.
Well, because, Your Honor, this was work that was being done for a very prominent California-based and headquartered company that has been run out of California for a long period of time.
It has its investor day in New York, and whose founder spends 100 days a year in New York.
But Your Honor.
And that's uncontested affidavits.
Yes, but Your Honor, every major corporation in this country ends up doing certain presentations in New York, the financial capital of the world. That is not the basis on which jurisdiction or statute of limitations or what the claims are based on. Here, the work was being done for a California-based company.
In New York?
Not in.
All the work was done in New York, according to the affidavit that you submitted.
Actually,
The presentation was done there.
The presentation.
Talking
was
to the
made-
investment makers. I guess some of it might have been made in London.
The presentation was made in New York on behalf of Alexandria, a California-based company. The contacts with California, the witnesses, the work being done for a California company, I think clearly California has a much more substantial interest in this case. None of this was done in Massachusetts, for anyone who resided in Massachusetts. So, Your Honor, I think the way to look at this is that done for a California company, at a California company's behest, that a California company would then have a presentation made in New York to potential investors where so many financial parties are present, doesn't in any way render the fact that California has the most significant relationship, particularly compared to Massachusetts, which had none. That's all I'm saying, Your Honor, and that really is all on the face of the plea.
Let me ask you about your forum nonconvenience argument. How is California a convenient forum for this case? I thought it would just be dismissed there.
But, Your Honor, the law on forum nonconvenes, and a New York court already fully litigated this with Stephen and Bugsby litigating
No, we're in
on the other side.
Massachusetts now.
I understand, but there was already a court decision in that regard that they had a full chance to litigate. And the court there ruled that California is a more convenient forum because the key witnesses in the case, Joel, Marcus,
But is it
Darren,
available,
Dean, and
is it an
others.
available form at all?
The fact, Your Honor, in forum non-convenes context, that the case now, because of the decision Stephen made on when to sue, or Bugsby made on when to sue, now that they would face a statute of limitations bar in California, does not render it a forum that is not, for forum non-convenes purposes, the right forum to have litigated in.
I mean,
It's not dispositive of that issue.
Maybe it's not dispositive, but it's a very important factor. In the Massachusetts cases, the defendant waives the statute of limitations in the form they prefer. I assume you're not doing that?
We agreed that certain claims could have been, made there, but we didn't waive our statute of limitations defense. No, Your Honor.
Okay.
And again, that issue only has to be reached if the statute of limitations issue is not dispositive in the first instance, Your Honor. Thank you very much, Your Honors. Thank you.
Thank you. That concludes our sitting for today. Many thanks to our court officers, members of the clerk's office, our law clerks and interns. That concludes our sitting.
Thank you.